continuing on audio-only basis for the proceeding where the violation occurred, and disqualification, if necessary, and narrowly tailored of the news organization that filed the request in order for electronic media coverage of court proceedings for the hearing in which the violation occurred from providing pool camera operator services in this matter, where the court determines that such a measure is required to ensure compliance with a standing decorum order and to protect the rights of the parties. Counsel will be allowed to provide their input before the court makes any final determination regarding sanctions. I want to emphasize that these measures are not intended to have a chilling effect on open and transparent courts or on responsible news gathering, and the court remains fully committed to the presumption of open proceedings under applicable rules. Rather, they're intended to protect the constitutional rights of all parties while preserving the integrity, openness, and fairness of these proceedings. Third, at this time, I wish to address the camera operator. Mr. Yulberg, if you wouldn't mind coming forward and standing at the lectern. And could you state your name for the record?
John Yulberg.
Thank you, Mr. Yulberg. It's not my intention to cause you any embarrassment or discomfort. I simply want to ensure that the guidelines for today's proceedings are clear. Mr. Yulberg, during today's hearing, what is your primary role?
To provide video coverage of the proceedings for the public.
All right. Have you read the December 23rd, 2025 Standing Decorum Order?
Yes, sir.
Do you understand the guidelines as they relate to your responsibilities today?
I do.
Do you need any additional time to review the December 23rd, 2025 Standing Decorum Order, or any time to reposition the camera to ensure full compliance with those guidelines?
Do I need more time? I'm sorry, was that the question?
Do you need more time to review the decorum order? And I'll pause there because that was a compound question. Sorry about that.
No, I've read it, I fully understand it, I'm good to go.
All right, to the second part, do you need any additional time to reposition the camera to ensure full compliance with those guidelines?
No, I think we're in a good position now.
All right. Mr. Yulberg, do you anticipate any difficulties complying with the December 23rd, 2025 Standing Decorum Order?
I do not anticipate any problems.
All right, and is there anything that the court can clarify to assist you?
No, I think we're good to go, sir.
All right, thank you, Mr. Yulberg.
Thank you.
Before I let you go, I'll turn to counsel based off the questions asked. I'd turn to you if you have any input or questions.
Nothing from the state.
Thank you.
No, Your Honor.
All right. All right. And the court, I appreciate your cooperation, and it's my hope that we all do our very best today together.
Absolutely. Thank you.
And finally, before we turn to the issue, the motion before the court, to the state, could you please provide a brief update on the status of discovery disclosure?
Yes, Your Honor. I don't have the percentage of materials that we have that have been disclosed, but I think we're above 90% at this point. There still is discovery coming in, there are reports and so forth coming in from various entities. So I think we're moving expeditiously towards completing at least this initial batch of discovery. Of course, discovery will be ongoing probably for the duration of the proceeding, but we have provided nearly all of what we have to date.
All right. And to defense, any input?
None at this time, Your Honor.
Thank you, Ms. Nestor. All right. Thank you, counsel, for your patience as the court covered those preliminary issues. Let's turn to the defense's motion to disqualify the Utah County Attorney's Office. Ms. Nestor, or sorry, Mr. Novak.
That's fine, Your Honor. That's okay. We actually have some preliminary things we want to discuss with respect to the posture of this motion. And I also think at some point the court needs to decide at what stage the hearing on this motion remains open and becomes closed. So I'm going to bear that in mind in terms of my preliminary statements, if I may. When we filed this motion to disqualify, and when I say we, I mean Mr. Robinson's counsel, we fully expected that what the Utah County attorneys would do is refer the motion to the Attorney General's office so that the Utah County attorneys are not in the position of representing their own interests as potentially conflicted attorneys in a potentially conflicted office and representing the state's interest in the prosecution. We heard informally from the state's attorneys that they were preparing a response and when it would be provided. And then what we received and again, I'm bearing in mind that we're in an open hearing at the moment, was a brief where I'm going to say the unsworn representations of two attorneys from that office are basically integrated into points and authorities. We don't have affidavits from Mr. Gray or from the other attorney. We have argument. We noted in our reply that we were surprised, that's in footnote 2 at page 4, that the Utah County attorneys were representing themselves in connection with a motion alleging that they have a conflict of interest and that the state was not being represented through the Attorney General's office. We did some further research on this, and we have some case law that we can provide the court. I suspect that the court is very familiar with the fact, just from its own experience, that in appropriate circumstances, the Attorney General's office can either, one, represent the state in what was a county prosecution with respect to a disqualification motion, so that the boundaries are clear, or if there's an ultimate finding or conclusion that there's a conflict of interest, take over the prosecution or assign it to another county. So we're very concerned that we're getting off on the wrong foot, if I can use that metaphor, because we have officers of the court who are both representing their own interests in continuing to be the prosecutors in this case and representing the state in a situation where there should be what I would call, at least temporarily, conflict counsel. I'm not sure that's the term the Attorney General uses, representing the state's interests. There's a Supreme Court decision which is called State v. Jimenez, Jimenez, which I can provide a citation for. There are subsequent cases, but it's pretty clear that this is the type of a case. I'm not saying that Jimenez compels that action, but it seems to me to strongly suggest that where there is a showing, I'm not sure what the threshold showing is. I don't want to say it's a prima facie showing or a reasonable concern, but where there's a showing that there very well may be a conflict of interest that hasn't been handled by a particular state attorney's, county attorney's office, that what's in the interest of the litigation, of the public, of the parties, is for the Attorney General to step in. And the citation for State v. Jimenez, if I may, is 588 P. 2nd 707. Of course, I can provide the court with the Utah citation as well. This court actually has the authority under that case, State v. Jimenez, to direct the Attorney General to step in, not for the entire case at this stage, that's not what we're saying is necessary, because that requires a finding of a conflict of interest, but to step in or to designate somebody to step in for the purposes of litigating that motion.
Okay.
And so we're very concerned that even going forward with an evidentiary hearing where members of the Utah County Attorney's Office are both litigating as representatives of the state in a prosecution and essentially defending their own propriety of proceeding in this prosecution is problematic. As far as being prepared, we're of course prepared to go forward with an evidentiary hearing, but we think that it's improvident. And we think that what the court should do, if the Utah County attorneys have not or don't, if given the opportunity, do this on their own, is that the court should designate the Attorney General's office for the purpose of litigating this motion. The court might ask, hypothetically, the question, has the Utah County Attorney's Office conferred with the Attorney General about this particular question? And we are not in the dark, because as Ms. Nestor will tell the court, as an officer of the court, she's spoken with the Attorney General's office, and they have not been consulted about this. Okay? So this is a motion to disqualify a county attorney's office based on what we believe is a material, significant conflict of interest that it's clear they haven't even tried to address by way of a screening, which of course is a term of art, because their position is no screening was necessary. We're not even here to discuss whether the way in which a particular attorney was screened off was adequate, their position as their own advocates is, we've already decided no screening is necessary. So what we've been told by the Attorney General's office, Ms. Nestor can represent to the court exactly what she was told, but basically that there has not been consultation. And while that is Mr. Gray's prerogative, we think it's wrong, and we think that this court needs to exercise its authority to intervene and say, in this case, for this kind of a motion, the court needs to hear from a representative of the state who does not even appear to have a conflict of interest. So that's our preliminary statement about these issues. And again, I hope I've avoided saying anything that should have been said in a closed hearing. I think I was pretty good about that. So that's where we are before we even get into the litigation of it. And I don't want to be formalistic, and I'm certainly not trying to be confrontational, but I think actually what we think the court should do is the court should strike the Utah County Attorney's response to our motion and direct the Attorney General to take up the responsibility for responding to our motion in whichever way clearly non-conflicted attorneys representing the state think they should, how it should be responded to. And if I've muddled, I always say this, Your Honor, if I've muddled anything or confused anything, please say so, and I'll try to clarify.
Thank you. I do have some questions for you as it relates to this. I wish to consider all the authority that you wish to cite to. I mean, obviously, you came into this hearing knowing that this is something you're going to present, and this court wants to be efficient with time, but thorough,
Yes.
and not jumping to conclusions. Can you give me all the authority that you wish for me to consider in considering your request today?
Yes, and I think what we could also do, which maybe would be more helpful to the court, is that we could file a short brief on this particular issue, because I will acknowledge that while we were surprised that the brief was filed by the same lawyers who are alleged to have this conflict of interest, it took us a little bit of time to, and we wanted to get that filed in time for today's hearing because the court had set the hearing. It took us a little bit of time to think through these issues. So there are Utah authorities, there are authorities from other jurisdictions, there are also ABA guidelines on the prosecutorial function, which we think strongly suggest that there should have been what I'll just call a referral to the Attorney General's office for this particular motion. I can stand here and I can give the court case names and numbers and sections from the ABA standards, but it was not our goal to, of course, put the court on the spot and require the court to, like, go back into chambers, think about it for, some pressured period of time and come back out and make a decision. So if it would benefit the court for us to file something, and I don't mean in a month, I mean very soon, so that the court has thoughtfully presented points and authorities, we're happy to do that. As far as I know, the only people who've traveled out of town for this hearing are Mr. Burt and myself, so I'm thinking about the convenience of witnesses in the court and counsel. It's important that we do this in a way where the court has the opportunity to make a thoughtful, reasoned decision, as Your Honor always says. So that would be our proposal, is that if the court is open to receiving authorities, that we recess this hearing for, whatever meets the court's schedule, whether it's a week or 2 weeks or a few days, and we can provide the court with something, and we'll come back. But we do think this is a serious issue, because I think the question of who litigates this issue on behalf of the state is in itself wrapped up in this conflict. And we want everybody to get this right. Once.
My question for you is, knowing this, why didn't you file a motion prior to today's hearing, knowing that the court would be in this position, based off your request, to prepare the court, prepare opposing parties, and to be efficient in our use of time? I'm trying to understand. I understand what you're saying, and I understand that things evolve, but I'm trying to understand why that wasn't filed in advance of the hearing to put the court on notice at the very minimum, and just to allow the court to do what the court does.